Okay, folks, we're now about to start Note 15, which deals with bankruptcy. Bankruptcy is a procedure which allows a debtor to be made free of their debts. The process is controlled by the Constitution. The writers of the Constitution felt that this was an important enough thing. They did not want to leave it to the individual states, so they gave Congress the authority to pass laws governing bankruptcy and to give the federal courts jurisdiction to handle bankruptcy cases. Um, the purpose under our bankruptcy laws is to basically give somebody what's called a fresh start, to give them a new beginning, realizing the fact that some people get themselves so far into debt, and very often because of circumstances beyond their control, because of the outside economy, because of illness or whatever, that there's no way they will ever be able to pay off the debts in their lifetime. And therefore, this process is here to free them of those debts, to allow them to begin again, and the Bankruptcy Code even uses the term fresh start as being, particularly in personal bankruptcies, as the ideal. This is a dramatic change from the common law and from English history and even the early colonial history. In England, right up through the 1800s, a person who owed debts and could not pay them would be jailed. They had debtors' prisons where people were sent for failure to pay their debts. Now, I don't know what the operational theory was behind that, because you would think that if somebody is in jail, they can't be working to earn a living to pay off their debts. However, I suppose it was an early form of GoFundMe. They thought that once they had thrown you in jail, some rich relative or your mother or your friends would get together, pay off your debts, and get you out. The debtors' prisons were very severe places. They were very awful places. Many people died in them, never having paid off their debts. And the colonists did not want this to become something that our law would carry over when they set up the new government. One of the options that a debtor had would be to enter into a period of service, to become an indentured servant, which was not slavery, because you had the potential at some point in time of working off your debt, but it was the equivalent to short-term slavery or to a limited-term slavery. You would basically sell your services out to someone, and they controlled you and controlled your life for whatever period of time. And a number of people ended up in North America and the colonies by way of becoming indentured servants, and some of them were there because they owed debts. And so I think the people who wrote the Constitution were probably reacting to their grandparents' and great-grandparents' stories about having been forced to immigrate to America and then work for 5, 6, 7 years to pay off their debts. The second purpose of bankruptcy, besides giving a fresh start to the debtor, is to make sure that the creditors are fairly and justly treated, so that one person doesn't grab everything and take off with it, or that the first person to bring a complaint doesn't get all the assets and leave everybody else in the lurch. So there's kind of a double-edged sword going on here. Bankruptcy does exist to give the debtor a fresh start, but it also exists to bring some order and some coherency to the proceedings on behalf of the creditors, and of course a creditor being the person who is owed the money. At present, the bankruptcy courts are a sub-branch of the federal district court. So in every city or state where there is a federal district court, there is also an adjunct to that, which is the bankruptcy court. There are specific judges now appointed as bankruptcy judges, and the cases run on a pretty much separate and distinct calendar from the rest of the district court. For those of you who are going to go into being paralegals, bankruptcy is one of the places in the law where almost everything is done by form. There are all kinds of forms to be filed with the initial filing of the bankruptcy. There are different procedures to be followed, and very often there is limited actual court time in the case unless a matter becomes contested. But for most of the situations, the bankruptcy proceeds almost as a ministerial type matter today, where the proper forms are filled out, the proper notices are sent, the proper time periods are allowed to go by, and then the court will issue the discharge, which is what the debtor is looking for. A discharge is saying that every debt that you named in the bankruptcy case is now null and void. You can never be chased for them again. No creditors can come after you for them. Now, there are various types of relief in bankruptcy. We just spoke of one, which is discharge. And in a discharge, the debts, the contractual obligations of the debtor are wiped out, they're over and done with, and they cannot be pursued on them ever again. But there are many types of situations where that is not the ultimate goal. For consumers, there's something called Chapter 13 bankruptcy, the goal of which is to get the creditors off of your back for a while, to make them all sit down and be quiet, and that you will eventually work your way out of debt, and eventually everybody will be paid. And then for businesses, there is something called Chapter 11, and many times when a business goes into bankruptcy, the ultimate purpose is not to dissolve it, to finalize it, which is what can happen if the business seeks to have all its debts discharged. One of the things that goes along with that is that the bankruptcy court can dissolve, the company can dissolve the business. But very often, instead of doing that, they use Chapter 11, very much like a Chapter 13 for an individual. They use it to help the company get back on its feet, to get rid of certain debts, to get rid of certain burdensome or bad contracts, and then once the company is free of those things, to allow it to continue in business, to continue having employees, and to come out of bankruptcy and proceed as a regular, privately run corporation again. Now, some of the things that you need to know. First of all, to file bankruptcy, you must be insolvent. The definition of insolvency is that your current income is insufficient to pay your currently due debts. So anyone whose bills have become higher now than their income, they are technically insolvent. They are eligible to file for bankruptcy. Having said that, I want to talk first about the procedures. Now, whenever an individual or a business files a bankruptcy case, they have their own lawyer representing them in bankruptcy. The bankruptcy court appoints someone called a trustee. And the job of the bankruptcy trustee, they work for the court. They do not work for the creditors or the debtor. Their goal, again, is to marshal the assets, to find out what assets are there, to gather them together, to make sure that any assets that are available are put into the pot, and then they supervise the process of seeing whether debts are discharged or paid or what will happen with that. So it's kind of a little bit different from regular proceedings where you have a plaintiff's attorney and a defendant's attorney. Here, you have an attorney for the debtor, you have attorneys for each of the creditors, and you have a trustee who works for the court. All right. To begin, you file a petition in bankruptcy. Now, that petition can be voluntary, which means the debtor themselves filed it and decided we're in over our heads, we want to seek bankruptcy relief. Or if it has reached a point where a debtor is not paying their bills, a creditor or a group of creditors can file an involuntary petition, and they can force the debtor into bankruptcy court. And they do that with the hopes for a business that somehow will go through Chapter 11 and come back out the other end and eventually pay them, or that the individual debtor will end up in a Chapter 13 and the creditors will eventually get paid part or all of what they're owed. When you file as an individual, a number of things have to go along with this. First, you must give a list of all creditors. Any creditor you fail to list is not a party to the bankruptcy proceeding. Even if you receive a discharge, any creditor who is not named, their debt will not be wiped out. You will still owe it to them at the end. So it's very important to make sure that list of creditors is as absolutely comprehensive as you can make it. Secondly, you must give a statement of your financial affairs. You must list all of the property that you own, right? You must give your current income and expenses. And in many cases, the court can require that you go to credit counseling. There are various services that offer for free or for payment counseling to debtors, teaching them how to handle their money, how to hopefully stay debt-free in the future. And as one of the requirements for receiving relief from the bankruptcy court, the court can order a debtor to participate in that counseling and provide a certificate showing that they had participated in this and that they had taken these classes. You must show proof of income for the last 60 days. You must provide a monthly income statement while the bankruptcy is going on. You must provide copies of your federal and state income tax returns. Taxes are not automatically discharged in bankruptcy. There are situations when they can be, but there are other times when they are not. And the trustee and the court need to examine your tax returns to determine what category your taxes fall into. You must complete all of these filings within 45 days of filing the initial petition, or the court will dismiss your case and state that it was for insufficient filings, that you did not follow the requirements, so therefore your case is now gone. If the court finds that you have sufficient income to pay your bills, that you may have thought you didn't have sufficient income, but if the court looks at everything and they make allowances for you paying your rent, if you're buying your groceries and gas for your car and transportation to work and all that, if the court finds that taking all your bills and taking all these other things into consideration, you actually do have, in their estimation, enough money to carry on, then they will dismiss the bankruptcy case. All right? One of the most important things about bankruptcy is that the minute you file the petition, and you can file the petition without filing all the other things we just spoke about, but the minute you file the bare naked petition, there's something in the statute creating the bankruptcy laws called an automatic stay. Now, a stay is a ceasing of all proceedings. The automatic stay here means that all collection activity, all bill collection, all payment of debts, all court actions that may have been going on against you, any mortgage foreclosure that may be pending, any retrieval of personal property under a UCC Article 9 security agreement, any attempt to repossess a car based on the lender holding the title. At the minute you file bankruptcy, all of these things are stopped until the bankruptcy trustee has the time to go through your assets, go through your debts, to figure out what's going on here. And if anybody violates this, it is a willful disobedience of a court order, of a valid court order. It is basically contempt of court, and you can be fined and in some cases possibly even jailed for violating the automatic stay. This is a very powerful tool, and I have had a number of clients. We do not do bankruptcies at my firm, but I have had a number of clients over the years who they were a day away from having their house foreclosed upon, and the morning of the foreclosure at 9 o'clock in the morning, their attorney files a bankruptcy petition of the bankruptcy court in Providence, and that stops the 10 o'clock foreclosure dead in its tracks. And until the bankruptcy court unravels what's going on, the foreclosing lender has no power to do anything at that point. They must stop. Now, the bankruptcy court can allow for interim payments to be made for certain things during the proceedings, and certainly in a Chapter 13 for an individual or a Chapter 11 for a business, the whole goal is to get you out of bankruptcy without wiping everything out, and so there would be some intense negotiations between the trustee, the lawyers for the debtor, the lawyers for the creditors, about keeping payments of certain things going during the proceedings. Now, having said that, there are also some things that automatically happen. Child support is not stayed by a bankruptcy. Divorce proceedings for child support, custody, domestic violence, and for enforcement of support payments are not stopped by the bankruptcy. They are not stayed. Investigations by the SEC into a corporation or a company, into the buying and selling of stocks and bonds or fraudulent activities on behalf of a company are not stopped. And statutory liens for real estate taxes, for property taxes, are not stayed by the proceedings. So whilst many things are stopped, there are certain things that the Congress has not given the court jurisdiction to stop. A secured creditor. Now, a secured creditor, we talked about this a little bit in Chapter 13. A secured creditor is somebody who has a lien over a particular piece of property. So certainly for most people, The most common form of this would be you buy a house, borrow money from the bank to buy the house. The bank makes you grant a mortgage. The mortgage is a lien on that property. If you buy a car and you pay for the car by way of a loan, whoever loans you the money is going to hold the title to the car. They have a lien on the property. So even though everything is stopped in the bankruptcy, lien holders of secured property get preference in bankruptcy court. They are allowed, they cannot act sua sponte or on their own. They have to go to court and file a petition, but they can file a petition to lift the stay. And once the stay is lifted, they cannot go after the debtor for cash, but they can seize whatever collateral, whatever piece of property they're holding that they have the lien on, and they can take that to sell to get back what is owed to them. There was a period of time, even though we do not do bankruptcies per se in our office, where I represented a law firm I worked with a law firm as their Rhode Island representative, and what they did is they represented a number of the major banks, and they had me going into bankruptcy court to lift the stay so that foreclosures could proceed against people who had stopped paying their mortgage. And that can happen even though the bankruptcy is not finalized. The secured parties, again, they have preferential rights, and part of that preference is to be able to go into court and to get their security released from the stay so that they can at least get that and sell that to get some, if not all, of their what is owed to them back. The debtor cannot move funds prior to the bankruptcy. They cannot create what's called a preference. They cannot move funds in such a way that one creditor will come out better than the other. So let's say we have a situation where the person owes money to 20 or 30 different people. One of those people happens to be their uncle, who they owe $10,000 to. If it is discovered by the trustee, and the trustee has a right to get all of your financial records, including your bank records, if the trustee finds that 15 days before you filed bankruptcy, you wrote a $10,000 check to pay off your uncle on this long-standing debt that had existed for several years, that will be called a preference, and your uncle will be required to put that money back into the bankruptcy estate. The bankruptcy court has that power, that if creditors have been given unfair treatment that makes them in a better position than other creditors, the bankruptcy court has the power to undo those transactions. If there are fraudulent transfers, if you have made any attempt to hide assets by giving them away, putting the title in somebody else's name, putting a false mortgage on and giving a mortgage to your friend when there really was no debt, any transfers made 2 years prior to bankruptcy will be scrutinized, and if it looks like they were done for the purpose of protecting this asset from the bankruptcy proceeding, then again, those can also be undone, or the bankruptcy case can be dismissed. All right, so somebody who is contemplating bankruptcy has to be very careful with what they do with their money, what they do with their funds, and they have to not rush into the bankruptcy quickly, because it could turn out that looking backwards, the trustee is going to classify some things, some transfers that you may have made innocently, but they're going to look at them and call them preferential transfers, or they're going to look at them as fraudulent transfers. That big gift you gave to your mother last year could be considered a fraudulent transfer, and you'll have the bankruptcy trustee asking her to give it back, or actually ordering her to give it back. Now, there are exemptions to what can be taken. Not all of your property has to disappear into the bankruptcy. And this is why, particularly when bankruptcies were running rabid in the late 80s, in the middle 90s, and again in 2008 to 10, many people complained, gee, so-and-so across the street, they went through bankruptcy, but they still have their house. They still kept their $500,000 house. There are reasons why that happens. Part of it is that there are exemptions. The federal law gives a list of property exemptions, things that cannot be seized and taken into bankruptcy. Some of these, for personal property, are your household furniture, your personal clothing, Bibles, family pictures, a low-value vehicle, livestock and pets cannot be taken, equipment necessary for your employment, so the tools of your trade cannot be taken, IRA and 401k accounts, where most middle class people actually have the large bulk of their wealth, apart from their residence at this point in time, they are not subject to bankruptcy proceedings. And funds that have been obtained from Social Security or workers' compensation, and not just your actual payment, but if you have a bank account and you can prove that all the money that's in there came from Social Security or workers' compensation payments, they are not subject to bankruptcy under the federal rules. The federal law also recognizes something called homestead. Homestead is a state right, and it basically is a provision under state law that says up to a certain amount, creditors cannot attach the real estate in which you live. In Rhode Island, this number is up to $300,000 of the equity in your house. Your residential house cannot be taken by creditors. In Massachusetts, that number can actually go up, I believe, as close as $500,000 at this point in time. And the federal courts are required, the bankruptcy courts are required to recognize this. So that is one of the reasons. The other reason being that many people have their houses so highly mortgaged that when they go into bankruptcy, the bank could take the whole house. If they can find somebody to make the mortgage payments for them while they're in the bankruptcy, they can come through the proceeding without the bank having foreclosed, and then they can set up an agreement with the bank after the fact to go ahead and keep paying the mortgage and keep the house. But the homestead works to allow people to keep their equity. Now again, this real estate, it must be your primary residence. You must not have waived homestead when you were applying for a mortgage or a loan or something else. And in Mass and Rhode Island, it is limited to a certain amount. In Rhode Island, it is automatic. As long as you can establish, I was using this house as my primary residence, you have the bankruptcy protection. In Massachusetts, you have it up to $125,000 automatically, but to get the higher amount, you have to file paperwork at the county registry of deeds stating that you have declared a homestead exemption in this property. Once the bankruptcy has begun, there will be a creditors meeting where the debtor has to show up and has to answer questions that are posed from the creditors. All right, so the debtor has to show up. This is called a creditors meeting. The debtor has to show up, and basically they're put on the witness stand under oath, and they have to answer just about whatever questions the creditors want to ask them. Part of this is that the creditors, again, are trying to establish were there any preferential transfers, were there any fraudulent transfers, or was there any fraud involved in incurring their particular debt. Because one of the things about the bankruptcy court is that if you obtained money by fraud, by lying on your application or cheating on your application, then you may not be eligible for a discharge. So it is much to a creditor's positive side, to their benefit, to have a lawyer present at this meeting and ask you pointed questions about what information you put on your application. And if they can make it look like you lied or you misrepresented your financial status or what you're going to use the money for, then very likely that particular debt will not be discharged and you will come out of bankruptcy still having to pay the same. Creditors who want to pursue their rights must file a proof of claim. It is a legal document signed under oath stating what they are owed, and basically it's their, as I said, proof of claim. They have to file paperwork showing the court that yes, we really do have a valid debt, a valid claim here. If a case appears to be no assets, meaning the debtor has nothing, the court puts that information into the notice saying that, oh, you are a creditor of John Smith, he has filed bankruptcy, you must file a proof of claim. But they also put a note in there saying this is a no asset case, and in 99% of no asset cases, creditors don't even bother to file claims because they know there'll be nothing to get. Now, once this is all done and the property of the debtor has been determined by the trustee, there are payments on claims. There is distribution. Now again, the secured creditors, they get the right to take whatever they're holding as collateral first and foremost. If that does not pay their debt in full, then they become a general creditor along with the other creditors, and they still have the right to get certain payment on whatever was not covered by the security. very often there is not enough money to pay everyone, which is why the person is in bankruptcy. So the unsecured creditors end up all being treated equally, and they all get a pro rata share of whatever money is left. I haven't looked at the statistics in many years, but the last time I did was in the 2010s, and basically creditors were being paid something on average of 7 cents a dollar coming out of bankruptcy cases. So again, many creditors never even bother to file once one of their debtors goes into bankruptcy, because there's nothing there for them to get. It used to be that the debtor themselves could choose, an individual debtor could choose to file a Chapter 7 or Chapter 13. Now, Congress passed a law saying that Chapter 13, where we're going to try to work this out and eventually get all the creditors paid, is the preferential treatment, and unless you can show extreme circumstances, you must file a Chapter 13 first. But again, the grim reality is that by far the vast number of debtors are unable to complete the Chapter 13 provisions of slowly paying off the debts and getting back to where everybody's on even keel and everybody's being paid. And the Chapter 13s can be converted into a Chapter 7 if it becomes apparent that the debtor's never going to be able to get out of this. And there are time limits in the statute and the court rules. Basically, a Chapter 13 can't go on for 20 years. You have to be able to show that they could work this out within a couple of years, and if that can't happen, or even if they get into it and it looks like that's not going to happen, then the case will be turned over to a Chapter 7, where the debtor doesn't have to make any attempt to pay everybody off in full and to keep making payments on the debts. There are, again, preferences in terms of distribution. So after the secured creditors take their property, their collateral, the priorities are child support and alimony, administrative expenses of the bankruptcy, expenses incurred by creditors in an involuntary bankruptcy, wages owed to employees of the debtor, employee benefit plans owed by the debtor to employees, consumer deposits. So if it was a business where they were taking deposits from people, those get paid first. Then taxes and penalties, claims for death, wrongful death claims, and then finally the general creditors get the lowest priority. They only get a percentage, a pro rata share of whatever's left, if anything. At the end of this process, the debtor is discharged in a Chapter 7, and discharge means you are released from your debt, your contracts, your governmental obligations. You can never be chased for them again. If somebody tries to chase you for them, they are in contempt of the bankruptcy court. Now, some things that are not discharged in bankruptcy, and people need to be aware of this when you are borrowing money and setting up things. It's important sometimes to think about this. 2 years worth of back taxes cannot be discharged. Amounts that you borrowed. So if you pay your taxes with your Visa card, you can't then go into court and discharge the Visa card. Claims against property obtained by false pretenses, or if you made false representations, which we talked about already. Claims of creditors who are not notified of the bankruptcy. Claims by anyone to whom you had a fiduciary relationship. All right, so if you're a fiduciary and you appropriated the funds of your ward or the person who you were in charge of, the beneficiary, they will be paid preferentially. Now, this should not happen, because if you are truly a fiduciary, the funds that you are holding should be set up in a separate account where it is named, where the beneficiary's name is on that account, and where it is known that that is not the fiduciary's money. It should not be under the fiduciary's tax ID number. So we're really almost talking about cases of fraud here, where the fiduciary had converted the beneficiary's funds to their own use. Those would be paid back first. All right. Claims resulting from the willful or malicious conduct of the debtor. If you intentionally assaulted someone and did bodily injury to them, that would be, their being paid for their damages would be a preferential claim. Government fines and penalties are not discharged. Student loans are not discharged. debt over $650 for luxury items if you bought that luxury item within 90 days of filing. So if you bought your significant other a $5,000 diamond ring 30 days before you filed bankruptcy and you bought that on a loan, that will not be discharged. All right. I think that is basically all I have to say. Is it? No, sorry. My own notes are in rough shape here. All right. If you took cash advances from any of your accounts over $900 within 70 days of filing, you have to give those back. Judgments resulting from a DUI, a driving under the influence, is not discharged. Fees to condo associations, if you still own a unit, are not discharged. And taxes, if you had failed to file or didn't provide adequate documentation, those are not discharged. So, as you can see, there's a very large number of items that will not be discharged in bankruptcy. There are bankruptcy attorneys that we work with that we refer our clients to when they get into trouble. And I've had my clients call me up a number of times after the initial consultation to say, oh, we're not filing bankruptcy. It's not going to help because we have this type of debt or that type of debt or this type of issue that cannot be discharged, so that they have actually advised us that bankruptcy will not assist us, will not work out at this time. Now, creditors have the right to object to the discharge before it is entered, and some of the grounds that they have for doing that are that property was hidden from the court or was destroyed. You can't, as we said, give away property, hide it, or not reveal the list of all your assets, the extent of all your assets to the trustee. If there was fraudulent concealment or destruction of financial records. If you had another discharge within 8 years. The basic rule is you can only file bankruptcy once every 7 years, and you can only be discharged once every 8 years. If you fail to complete the consumer education course, or if there are pending felony proceedings against you for the repayment of fraudulent debt, the creditors can object. Now, a debtor can choose to keep paying certain things. And this most often happens with mortgages, with car payments, or with car leases. So theoretically, your mortgage could be discharged in bankruptcy, but the lender, the bank, has the right to come and take the house in foreclosure. The same thing, your car loan or your lease agreement could be discharged in bankruptcy, but the people who actually hold title to those vehicles are not you at that point. They have the right to come and take the vehicle. So there are many situations where people go through bankruptcy and they don't want to give up the house, they don't want to give up the car, and they can agree to enter into a reaffirmation agreement. All right, so basically they go to if it's their house, they go to the mortgage holding bank and say, we're in bankruptcy, but we want to make this clear with you. When we get out of bankruptcy, we'll bring the loan up to date and we want to keep paying. And the debtor very often will agree to this. Now, in order for this to be valid, there must be a written agreement laying out all the terms of this. It must be filed with the court, and the bankruptcy judge, has a right to review it. And if the reaffirmation places an undue burden on the debtor that the court thinks the debtor can't pay, or it's in some way unfair to the other creditors or unjust, then the bankruptcy court has the right to refuse to accept it. But as we said, one of the big complaints going back 12 years ago during the real estate and banking crisis was many people, the neighbors, knew they were in foreclosure, they were about to lose a house, they filed bankruptcy, and lo and behold, 2 months later they're walking around saying, oh, we got discharged in bankruptcy, but they got to keep the house. This is one of the ways that they get to keep the house. Now, the effect of a discharge. All debts are erased, all judgments are set aside, all collection activity must stop. One caveat here, if you fraudulently went through the bankruptcy, you lied about assets, you lied about certain things, a discharge can be revoked within a year if somebody can bring forth proof that you had not told the truth, you had not been upfront in the proceedings. Now, talk a little bit about bankruptcy for businesses. Chapter 11 is the basic section of the bankruptcy code and the federal law that deals with businesses filing for bankruptcy. One of the main goals of Chapter 11 is to create something called a workout, a situation where terms can be renegotiated, debts can be renegotiated, and that eventually, hopefully, all gets paid at a reasonable point in the future. Very often, to accomplish this, something occurs which is called the debtor in possession. The bankruptcy court and the bankruptcy trustees, they do not know how to run businesses. They're not experts in that. They're not specialized at that. And if we're trying to keep this business going, if we're trying to work it out, the business has to keep operating. So very often what happens is, rather than the trustee taking over and trying to run the business, we have a situation where the company filing bankruptcy petitions to allow the debtor themselves to remain in possession. And what that means is that the board of directors and the officers continue to operate the business, albeit under the supervision of the bankruptcy trustee, but they are the ones who are still doing the day-to-day running of the company while the company is in bankruptcy. Once a company files for Chapter 11, a creditors committee is appointed, and these folks are representative of all the creditors, and they're there to make sure the creditors' interests are watched out and are taken care of in the proceeding. The first major step in a Chapter 11 is something called a reorganization plan. It has to be drafted and submitted to the court. If the debtor is in possession, it will be drafted by the board and the officers in conjunction with the trustee and the lawyers of the debtor. And it would describe the steps that are going to be taken to keep the company alive and to do minimum damage to the creditors. It must be filed with the court, and it must be accepted by each group of creditors, I believe by a majority of each group, so it doesn't have to be accepted by 100% of all the creditors. And then it must be confirmed by the court. The judge must review it and determine that it is appropriate and proper and meets the bankruptcy laws, and then it can be accepted. And then the company goes forward operating under this plan, which might include extension of loans so that payments are lower. It might include lowering of certain fees and things that are due. It might include some creditors not getting paid their full amount, but agreeing to take a certain percentage of what's owed to them. If the creditors refuse to, in good faith, deal with the reorganization plan, the court has something that we in slang call a cram down power. And the cram down power means that the court can force creditors to accept a plan, even though the creditors are saying they refuse, they don't want to do this, they're not agreeing to it. One of the biggest ways that cram downs are used, and the one that I'm most familiar with, has to do with real estate. If a company is leasing a building at a very high rent that maybe 3 or 4 years ago was the going rent for that building, but now rents in that area, in that city, or because of the economy, have come down dramatically, and new leases are being signed for half of the rent that this company is paying. One of the ways in which a court can do a cram down is the court can go to the landlord and say, look, if this lease had come up and was ended, or if we discharge this debtor completely, they no longer own you any money, you're only going to be able to rent these offices for half of what you're getting from them. We're going to rewrite your lease, and we're going to say you now get half the rent of what had been agreed to for the next 5 years. That can happen with all different types of contracts that businesses have. And it's a very powerful tool to get the creditors to go along and to accept something reasonable. In a situation where there's a reorganization plan, the plan must reach its successful endpoint. So every plan basically says we're going to do this, do that, we're going to lower certain debts, we're going to extend other debts, we're going to make payments on this, we're going to get rid of that debt entirely, and at some point in time we will again be able to operate as a company paying all of our debts without the supervision of a trustee or the court. And that has to be within a reasonable time that should happen. The court maintains control of the company, the court remains in charge until we actually reach that point where the plan has been fully carried out. Now, having said that, this can take a process of years. Years ago, there was a company called the Penn Central Railroad, which tried to be the Amazon or the Walmart of their day. They started off as just being a Pennsylvania company. They went crazy buying railroads all up and down the East Coast and as far west as the Mississippi River. And eventually they became too big for their own good, and highways and trucking took over much of what the railroads used to do, and they went bankrupt. I believe they were in bankruptcy for 10 or 15 years before the entire mess was unraveled. All right, so it can go on for a long period of time, but it's not, the company does not come out of bankruptcy until the plan is granted, and people can go back in. During this period of time, the plan, of course, can be reworked. The debtor, the creditors can go back into court and ask for revisions to the plan on the grounds that we tried this, it's not working, whatever. I believe there is something called Chapter 12, which is a special form of bankruptcy for farmers and for fishermen. And there, again, they are treated similar to a business. The idea is to keep the farm, to keep the fishing boats and the equipment, and to keep these people working to keep things going on them. On the very last page of the notes, there is a list of the federal exemptions for property. Now, there's an interesting thing. States have exemptions to their judgment laws. So basically, those are things that creditors cannot attach. And in some ways, the Rhode Island exemptions are very similar to the federal exemptions, but they're not always exactly the same. So one of the things that can also happen in bankruptcy is that your bankruptcy attorney needs to look at your particular debts and your particular assets and determine, because you have a right, you can opt at the beginning of the bankruptcy, you can opt to just accept the standard federal exemptions, and so you'll keep whatever property the federal law says you can keep. However, if the types of property that you own and the amounts of property that you own would be better saved by using the state exemptions, you have the option to do one or the other, but you must choose this option at the beginning of the bankruptcy. I don't believe you can switch it midstream. So a bankruptcy attorney who is really serving their clients will sit down with them initially, go over all their assets, will show them the schemes of exemptions and say, all right, if we file under the federal plan, you get to keep this, this, and this, but not this. If we file under the state of Rhode Island or Massachusetts, you get to keep this, 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 but not that. And help the client come to an informed and intelligent decision about which way to file, which will help them keep the most useful assets for them. All right, that is all we have to say about bankruptcy. Over and out.